and also to provide an accounting every 6 months of whether they are achieving that reduction or not. In other words, if you have a classic trust case and somebody stole money from a trust account and the trustee let that person do it, this is really just the remedy you would seek in any classic trust case. You'd want an accounting of how much was stolen, and you would want a plan for getting it back, and then you would want to make sure that the judges check in to make sure this is actually happening. So the judicial relief is not at all extraordinary. It is fairly mundane. It stays well within the judicial boundaries, but it forces the political branches to do what they must do and what they are charged to do under the law. They are charged to protect these natural resources. So it puts the burden on them to figure out how to do it and then come back to the court to say, we have done it. So the court's not going to tell a particular state to shut down this coal-fired plant or to put in so many bike paths. The court doesn't figure out how to do it. The court just says, here are the parameters. Here is your fiduciary obligation. You figure it out. And you come back with a plan, and you show us with a carbon accountant that you have done that. So I have finished this overview, but it really wouldn't be complete unless I could tell you what I really feel about this crisis and about the role of lawyers. Whether you are a trust and estates lawyer, a criminal lawyer, a trial lawyer, an environmental lawyer, this is all hands on deck time. This is all hands on deck time. This is a time where law has to be relevant. For law to be relevant, lawyers across the country have to come forward, and they have to find their role in this climate crisis. And so I really urge all of you, and we'll have more time to talk about this as the panel goes on, to find your role in this crisis, because this is the only time when environmental law has to be relevant for the survival of humanity. Thank you.
Okay, my name is John Meldrum, and I'm an attorney at the Western Environmental Law Center, and today I'm going to be talking about how to turn the theory of ATL into an actual lawsuit, and talk about some of the ongoing cases that were filed last May, just kind of give an update on them, and some of the hurdles that we've been facing in the litigation process. So there were 9 original lawsuits, and then since that time there have been 2 more lawsuits based on administrative petitions. Based on administrative petitions that were denied by agencies. So the states where there's active litigation is Alaska, Arizona, California, Colorado, Iowa, Minnesota, Montana, New Mexico, Oregon, Texas, and Washington. In all these cases, I mean, there are state-by-state variations in the relief that was requested and the exact procedural mechanism to get this before a judge. But I think it's important to talk about the relief of what we're asking before I talk about some of the challenges these cases have seen. So what these cases are all asking the judge to do is first declare that the atmosphere is a public trust resource. Without that declaration, these cases don't go any further. And once we say that the atmosphere is a public trust resource, we want the judge to declare that the state has an affirmative responsibility to not only protect that resource, but prevent harm to it. And if harm has been inflicted upon the asset, they need to do something about it and fulfill their obligations, which are based on the best available science. And after that declaration, as Professor Wood talked about, we want an accounting of carbon emissions and continuing accounting to make sure that the emissions are being reduced by an amount necessary to achieve what sound science tells us we need to be at in terms of emissions. And obviously ordering the state to not only just monitor emissions, but do something about it. So when we were filing these actions, we kind of looked at a few different mechanisms to get these cases before judges. In a normal trust case, a financial trust, you just bring a tort action against the trustee for breach of fiduciary duty. We thought about that. There are a number of problems with that I won't get into now. another is a writ of mandamus, and eventually all the cases were filed under were the Declaratory Judgment Act. And most states are based on the Uniform Declaratory Judgment Act, so it's pretty similar for all the states that we're talking about here. And basically under the Declaratory Judgment Act, a judge has the ability to make these declarations that we're asking them to make. And the purpose of that is to resolve conflict between parties so that they know what their legal obligations are and what they need to be doing to stay within the confines of the law. But an important part of this, in order to get in front of a judge under the Uniform Declaratory Judgment Act, is that you need some sort of interest, some sort of legal right that you believe is being impinged upon by the other party. And without that legal right, the judge cannot make a declaration of your rights. So this gets back to declaring that the atmosphere is a public trust asset. If the atmosphere is not a public trust asset, you don't have a legal right, and the judge cannot make a declaration as to whether the state is violating your rights. So in a number of these states, the first thing that is coming up is the motions to dismiss. And there's a lot of the usual things, standing, but some of the key issues deal with the Uniform Declaratory Judgment Act, because standing under that is slightly different than your normal standing. And some states, like Arizona, doesn't even have a constitutional standing requirement to begin with, even though courts usually still require it. But another problem is convincing a judge that the harm can be redressed. So even if the judge agrees with us on all points, says that the atmosphere is a public trust asset, the state has these obligations, if the judge orders the requested relief, is that really going to solve the problem? And from a practical standpoint, if the state of Arizona reduces emissions by a certain amount, that alone is not going to solve the climate crisis. But it's still a very important piece of the puzzle. Each state, each country in the world needs to use these emissions reduction, or implement these emissions reductions and require them, because without each piece of the puzzle, you're not going to get to the global carbon reduction that is necessary to prevent the catastrophic harm that Professor Wood was just talking about. So that's been a challenge, because a lot of judges have just been unwilling to even hear the case, because they don't think that, well, even if I have the power to do this, my action here is not going to solve the problem, and your client is still going to be suffering the harms that you alleged in the complaint. Another big issue is the political question doctrine, which has to do more with separation of powers. The courts cannot do things that impinge upon other branches of government, namely the legislature or the executive. And there also have to be some sort of standards by which the court can look to I guess, implement your requested relief. So the states are saying that this is asking the judge to make policy determinations, saying that it's a good thing to reduce carbon emissions, it's a good thing to prevent, or that climate change is real, and that you're asking the court to make this policy determination that's better made by the legislature. And the legislature, being the voice of the people, the elected representatives, can then decide what the policy of the state should be. Should we reduce emissions? Is this going to hurt the economy? How do we go about doing this? And a really important part of the relief is that none of the cases ask the court to order the state to do anything in particular. We ask the court, look at sound science, establish a threshold for what emissions need to be at and how we need to reduce them to get emissions below that level in a certain time frame. But state, you have the ability, or you can do whatever you think is best. And that doesn't just mean close down coal-fired power plants. It could be land use decisions. It could be investing in public transportation and other things that can reduce emissions in the aggregate. It doesn't have to be any particular policy. So by allowing the state to do that, they can do what they feel is best, but they still need to, Jack was talking about, we need outside of the box thinking. But the public trust doctrine also creates a box, and the government must act within that box. They can't be outside of the box. And right now, we are outside of that box. I mean, just the amount of emissions we're emitting, it's not sustainable, and we're, have a whole slew of problems coming down the line. And so government needs to be within that box, which is what the public trust doctrine says, but based on sound science says the state needs to be in. So it's not really implementing any policy decisions. It's the court has a check on the legislature and the executive, part of the checks and balances system. They are ensuring that the legislature and the executive are acting within the requirements that the public trust doctrine imposes on them. And it's not making policy decisions, it really is ensuring that the policy decisions that are made are comporting with their legal obligations under the doctrine. So lastly, is displacement. The states are arguing that we have these regulatory schemes in place, the Clean Air Act on the federal level, or each state has their own equivalent to the Clean Air Act. And the argument is, well, we have this, we're already doing something, so this displaces the public trust doctrine, this common law doctrine, which isn't based in statute, but just based on the sovereignty of each state and country in the world. It is, it's not displaced, it still is that check